Good morning, everyone. Happy Monday. I am Carol Williams, and I am back with another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, the first thing I want to talk to you all about is the $100,000 filing fee in relationship to H-1Bs. So we got some news from the federal court that said that it was considered an improper tax by the federal government, and thus the $100,000 fee was no good. We were all very excited, still kind of excited. Then we knew that the government was going to appeal that decision, as they are certainly able to do. So the government went back to the court and said, hey, listen, we think we're going to win on appeal, and we think it would be incredibly burdensome for us to approve applications, not charging the $100,000 fee, win the court case, which again, we think we're going to do, and then have to go back to those people and collect the $100,000 fee after we win. So the judge was swayed by that argument. So although the court decision is that yes, the judge ruled that the $100,000 fee was improper and an improper taxation, the judge also said, now you can actually, government, you can keep the $100,000 fee in place. We're going to see how this plays out, but we're going to move this along fairly quickly. We're not, we're going to have a very tight briefing schedule, hearing schedule, so that, we get a resolution to this fairly quickly. So all that leads up to a big we'll see. But as of right now, although the judge did determine that the $100,000 fee is an impermissible tax, the judge is letting the government still charge the $100,000 fee. So that's where we are with that. I will keep you up to date. If you think that you are subject to the $100,000 fee, I would highly recommend that you have a conversation with your current immigration counsel if you have not already. The next thing I want to talk about is there's been a lot of talk recently in immigration circles about the proper way to sign applications, the proper way to have our clients sign the applications. So for a very, very long time, I've been practicing for almost 30 years. So for a very long time, for the majority of my practice, we had to file wet ink signatures, meaning the client had to sign in ink on the form, send the forms back to us, and then we would file using their wet ink signature. Not a copy of the signature, certainly not an electronic signature, but a wet ink signature. During COVID, the Immigration Service said, okay, life is a little back to front and upside down right now. We're going to allow you to still wet ink sign, but now you can copy that wet ink signature, scan it back to your counsel or mail it back to your counsel, whichever you prefer, and then you can file that way. So they no longer required sort of the wet ink signature be sent into the Immigration Service. Then fast forward, immigration has started to use more online capability, where you are signing directly into their system. So the Immigration Service, however, now has said in an interim final rule that they are still not accepting electronic signatures. And by electronic signatures, I mean when you are on your computer and the computer says, pick a font, any font, or we've already picked a font for you, type out your name. And then when you print that form, your name types out in this beautifully printed font. The Immigration Service does not like those. The Immigration Service has never liked those. And the Immigration Service has now put in an interim final rule that they will not accept those. The Immigration Service has also said in this interim final rule that if they suspect that the signature on the forms is not valid, that they will, in their discretion, reject or deny an application. So make sure that you are following the immigration's rules for a proper signature. A proper signature has never been an electronic signature. If you are not sure if your signature is proper, then I would highly recommend that you have a conversation with an immigration lawyer so that they can walk you through what immigration is now saying is a proper signature. Also, if you sign a you wet ink sign, and then you scan that page, that signature page, to your counsel, you should keep the original wet ink signature just in case immigration has any questions that was not actually your signature or that it was not a valid signature. So you want to keep that wherever you keep your other immigration documents. So we've sort of been having that conversation within my immigration circle. So I wanted to let y'all know about that. The Department of State, sometimes I feel like the Department of State feels a little left out of updates. So every so often they come up with some things that I want to tell you guys about. So what they've come up with most recently is that they have a temporary final rule. So think of this as maybe sort of a pilot program on their part, but it's a temporary final rule, and it is allowing an expedite fee of $750 to schedule a B1, B2 visitor visa appointment. To be clear, this $750 expedite fee does not in any way, shape, or form guarantee an approval of your B1, B2 visitor visa. All it does is essentially allows you to skip ahead in line and get an appointment scheduled. All it does is let you schedule. It does schedule quicker. It does not guarantee an approval of that B1, B2 visitor visa. So comments are still being taken on the temporary final rule. Those comments will be due July 9. So if you have thoughts, let the Immigration Service know. And the last thing I want to talk to y'all about this morning are, it seems as though immigration is kind of transitioning a lot of their payments to, or some, maybe not a lot, some of their payments to pay.gov. And we have seen applications for applications that have for visas overseas at consulates that have been placed on hold because the fees were not paid using pay.gov, even though folks have been saying that they were never instructed to pay the fee using pay.gov. So we're not sure what's kind of happening. We've seen this for blanket Ls. So we're not sure if this is sort of a blip on the radar. We're not sure if maybe a few consulates have just had some issues with their particular payment systems. And sort of pay.gov is kind of the backstop for this. So we're trying to figure that out. Once it's figured out, if it's going to be something that is sort of more across the board, we'll certainly let you know. If it is going to be more across the board, I think Department of State will, in fact, at some point issue guidance for us as to when those fees need to be paid, or instructions for their consular officers as to how to instruct the applicants. But we are seeing that. So just kind of keep your eyes and ears open if you are filing for a blanket, and let us know if you have any questions on that. So, but I just wanted to bring that to your attention. That has kind of been a blip on a few cases. But that is all I have for you this Monday morning. If you have any other questions or concerns about your immigration case or strategy, feel free to reach out to our office. Happy to get you in for a consult and see how we can help. Have a beautiful rest of your Monday. And